Hello and welcome to the Kenneth Verkaman Law Office Legal Podcast. In this edition, we look at challenges to the wills. And in New Jersey, there are only a few legal ways to challenge a will that's been admitted to probate by the surrogate. Those are incapacity, fraud, undue influence, revocation, and sometimes improper execution. But the standards are very high and it's very difficult. For example, incapacity, the mental capacity for someone to do a will is not very high. They just really have to know that they have things to give, who they want to give it to, and no one's forcing them to do it. Fraud is an analogy where someone is, let's say, forced or tricked into doing it, into doing the document where someone might have said sign here and this is what it says and they didn't read it ahead of time. Revocation is where there's an allegation someone had revoked or canceled their will after it was signed. And improper execution is where there's a challenge that it wasn't properly signed, but those usually do not win because there's under the new probate statute, writings intended as a will could be admitted to probate. So the major way that individuals challenge a will is based upon undue influence. And the cases that describe undue influence in New Jersey are In re Dodge and In re Stockdale. Stockdale was decided just a few years ago by the New Jersey Supreme Court, and it looked into where a neighbor kind of tricked his little old lady into redoing the will. So instead of her assets going to the Spring Lake First Aid Squad, it went to him, and the court said he used undue influence on the little old lady. So it's common also where, let's say, one child lives with the parent, or the parent lives with them, and all of a sudden they do a new will. There's more information on undue influence and other challenges to wills on our website, njlaws.com, and also our website, njwillsprobate.com. And for representation in these type of matters, contact Ken Verkaman's office in Edison at 732-572-0500. Thank you.